Your medical practice has grown, more patients, more staff, more partners. But if your legal foundation is the same from day one, it could cost you.
We are seeing practices acquiring smaller practices. The deal looks great at the start, but the personalities were not right. You buy a practice, the doctor comes in, they're meant to be doing what they're doing, but actually it just causes relational issues. The documents can do whatever you need to do, but the documents should be the last thing that you rely on. You actually want to make sure the relationships are right. So finding the right target, finding the right practice to acquire is really, really important.
In today's episode of Investing for Doctors podcast, I'm joined again by Justin Fung, Head of Commercial Law at Avant Law, to walk you through the real legal risk of practice ownership, especially when it comes time to scale or even sell. In this episode, we'll cover how to legally structure your practice to grow and exit cleanly, the biggest legal traps in buying or selling a clinic, and why waiting until a dispute to review your shareholders agreement is a little bit too late.
You need to constantly come back to that document. Is it fit for purpose? Reassess that document regularly. The last thing you want is to kind of put that document in the drawer. 20 years later, 30 years later, someone's about to exit and the document just doesn't do the job anymore.
If you run or plan to run a medical practice, this episode could save you from a costly legal mess down the track. Now, without further ado, let's get into it. Hello, everyone. Welcome to another installment of the Investing for Doctors podcast. I'm your host, Dr. B. And today we have Justin Fung again from Avant Law with us. Hi, Justin.
Hi, mate. It's great to be here.
Yeah, good morning. So, Justin, give us the quick summary of who you are, what you do, and what's your practice.
Yeah, so I'm the general manager of Avant Law, but I also have a responsibility as a head of commercial and corporate law at Avant Law as well. And I'm happy to explain what that means because people go, what does the commercial corporate law mean?
Yeah.
Basically, it's helping doctors and practices work through their commercial legal issues, everything from buying and selling, doing a deal. That's
awesome.
Basically what we do.
Yeah, and that's the topic for discussion today. It's about buying, selling a practice, and you're the right person for the task.
Yep, no, happy to have a chat about that.
Okay, awesome. So now let's just set the scene. You know, I'm a specialist cardiologist, for instance, which I'm not. But for the case study, if I'm a specialist cardiologist, I want to either set up my own practice or buy into a practice or to join a practice.
Yes.
So we'll go through those three separate sort of scenarios and we can workshop a little bit on what that looks like from the legal perspective and, who are the other people you need to engage because, the legal profession doesn't work in isolation.
Correct.
And I guess before we start, we're going to do a general disclaimer. This is not legal advice. See a lawyer if you want to have more
that's
information.
Great. You should become a lawyer. I know you had the opportunity to become do a law degree at some point, but
Yes, I gave that up. And actually a lot of my classmates ended up being lawyers. And I remember when I was going through my own undergrad, when I went back home to visit them, to catch up with them at uni, I sometimes sat in a few law degree lectures. So that was fun. Anyway, back to the task at hand.
Yes.
The first scenario is, I'm a cardiologist and I want to set up my own practice, which is, renting a space, getting staff, buying equipment.
Absolutely.
Talk me through how that process works.
Yeah, absolutely. Look, you're absolutely right. When it comes to setting up a practice, there are lots of moving parts. And I think that if you're an individual cardiologist, making sure that you've worked out just your business structure. Am I going to be a sole practitioner? Am I going to be have a trust? Am I going to have a PTY limited company? Am I going to set a self-managed super fund? All those are good questions. You want to have a chat to a lawyer and also an accountant to kind of work through that. So usually at that point, the accountants and the lawyers are having conversations together, and you probably want to bring them in together. Make sure that they're across everything at the same point. The accountants can obviously give you the tax structuring advice. The lawyers can help you with the documentation and to kind of work with accountants to kind of come up with the right documentation that captures the structure that you want. I think once you've set up the structure, you're going to then think through, well, what is my plan? Is my plan to kind of be in a small, simple practice for like a long time?
Single person practice.
Correct. Or am I thinking a lot bigger? Am I thinking of scaling in a certain way? Am I thinking of doing acquisitions? Am I thinking of simply passing my practice on to an existing associate that I bring in a later stage? Or am I thinking of selling out to investors or a big corporate? Having those sort of conversations and thoughts are really important.
Yeah, beautiful. So let's do a bit of role playing. All right. I initially just want to maybe set up a practice for myself and one of my colleagues.
Yeah.
So we're going to obviously need some space. We're going to hire some reception staff. What does that engagement with the, lawyer look like?
Yeah.
Obviously, I've already got accounting advice. The accountant asked me to set up a company for this. The other cardiologist doesn't want to be part of it. They just want to, contract out. So
correct.
I'm staying a sole trader. I've got a company which runs my clinic. Where does the legal profession
how do you
step into
do that? So, I mean, sometimes, just assuming you want to set up a company, PTI Limited, kind of reduce, I guess, your legal exposures in a certain way from the individual kind of acts that can kind of come to play. You might want to set up a company. Typically, you'll set up some sort of shareholders agreement if you want to, at some stage in future, keep the option over bringing in other people. So you've got people that are essentially shareholders, that are part owners in the business. You might, at a particular point, be the only shareholder. But at a later stage, initially, you might want to bring other people in. So you want a mechanism to be able to issue shares to allow people to buy in. Usually those shareholders will be directors as well. So you want people that are able to not only own a part of the business, but have a say in directing how that business should operate. So once you've kind of set that up, you then think through, well, what are the other things I need to do in terms of setting up practice? Obviously, you mentioned finding a place. So finding a place, am I going to lease a place? Am I going to buy a place and develop it? If you want to lease a space, then obviously then you've got to find a leasing arrangement that's suitable for you, review and the terms of that lease. Correct. And the commercial terms, and making sure that, do I need to have certain options in place so that I can renew those options and exercise those renewals so that
what does that mean?
So basically every lease will have a fixed term, and then you want to have a lease, especially if you're planning to stay there for a while, that gives you the opportunity to exercise an option to stay longer for further terms.
So it's like, say,
correct.
4 + 2 + 2.
Correct.
Kind of
exactly.
I mean, I know what that means. Explain to our viewers what that means.
So basically, when you exercise an option, you can basically exercise and to basically use that space for another term of a fixed period. So whether it's another 3 years, by another 3 years, by another 3 years, or whatever the sort of the arrangement is. And every lease will be slightly different. Every landlord will have a slightly different set of terms and conditions. So having a lawyer who can kind of step you through that and just help you understand how to negotiate that as well. So most leases will be able to be negotiated. So having a property lawyer that can help you do that is really, really important.
And explain to our viewers what an option means, because on the lease, say, let's just use the 3 + 3 + 3 rule. After I've stayed the first 3. And if I wanted to extend another 3.
For another 3 years, that's the exercise of an option.
That is my right.
That's your right to exercise.
It's not the landlord saying, no, we're going to kick you out after 3 years.
The landlord can't kick you out. You've got the ability, provided you provide a certain notice period, and the lease will set exactly how many days you need to let them know that you intend to exercise the option, and what the mechanism is. Once you've complied with the terms, you can then basically say, I want to use this space for another 3 years. The lease provides me with the ability to choose to do that. And provided I've satisfied certain requirements under the lease, I get to stay for another 3 years or whatever. And then sometimes if you negotiate it out front that you want to have the opportunity to exercise for another 3 years after that, then again, you want to make sure that's all built into the lease to give you that longevity so that you can't be thrown out after the first part of the term. So, I mean, I guess that's very important to have. And you probably should get a lawyer to have a look at that. To make sure. And look, make sure that whatever the mechanisms are built in for you to, exercise that choice to stay longer are there. You don't want to be caught out sort of, not being able to kind of tick off on those requirements, and all of a sudden the landlord says, see you later.
Especially if you invested money for the fit out.
Correct.
Renovating the place, you don't want to be kicked out after a short period of time.
Absolutely.
Beautiful. So that's the lease, and obviously buy, then that's a...
so if you buy pick up the place, you're going to make sure that, obviously we've got property lawyers that will know this area much better than me, but you want to make sure that you're buying in a way where it's appropriately zoned for you to fit out a medical space. You probably want to, at this point, get property consultants in as well. So there are lots of property consultants that we're connected with that will make sure they source the right space for you. They will look at, I guess, whether there's patient foot traffic coming through. You can then build that into your model for kind of starting and growing the practice. They'll make sure that the regulations in the kind of the zoning, or whether the local council just
permits that,
right? It's a permitted use. And then they can also give you guidance on the fit out. We can help you with looking at the legal documentation around the fit out and making sure that everything's in place. The last thing you want is to kind of engage a fit out company and then all of a sudden your expectations aren't met and your legal rights aren't protected. So we can help with that. But having a property consultant in place.
Yeah, and when you mean property consultant, you mean like a buyer's agent?
Yeah, like a buyer's agent that can kind of step you through that process and identify the right sites for you.
Yeah, beautiful. Okay, so now I've secured my place. I've got my company set up. You mentioned the shareholders agreement and constitution. At this stage, I'm the sole owner of it. Is that something I need today, or is that can I defer that until?
I think it's good to have in the first place if you're thinking of plans to bring other people in. But it obviously becomes a lot more simple, right? Like if you're the sole shareholder and director, it's much easier. Look, if you intend to kind of stay the sole shareholder and director for forever, I just probably don't worry about having a full shareholders agreement.
Yeah.
But if you are thinking, and most people are thinking a bit bigger than just themselves, or even bringing associates at a later stage who may want to become business owners, having that agreement in place is probably helpful at this stage.
I mean, for those that don't understand, there's actually a templated shareholders agreement, which I guess does that default to that if you didn't have one and then you brought on another shareholder, or you must have a shareholders agreement?
Yeah, look, it's generally recommended that you have one. Look, not everyone does one. As you said, there are options for you not to have one.
Yeah.
But generally speaking, we would recommend one just because I think that if there are disputes at a later stage, having something in place is important, and having that looked at from time to time is important as well. We're coming up with a lot of situations where clients have come to us and gone, oh, look, this is the shareholders agreement that we put in place 20, 30 years ago. But we now want people to sell out, people to buy in, but we've got issues because the document is no longer fit for purpose. So having that sort of looked at from time to time is really important as well.
Have you got some examples?
Yeah, we've got some examples where literally 20, 30 years ago, the document was entered into and the circumstances have changed, new partners and new shareholders have come in over time. And then also we've got kind of people who are trying to exit. I think that's where it gets a little bit complicated when you're trying to exit, but the terms of the previous agreement that was entered 20, 30 years ago just
do not cover the exit.
Don't cover the exit appropriately because people weren't thinking about it at the time. So I think that's why whenever you start something, think about your endpoint as well.
And is that the issue with valuing what their shareholding
everything
says,
from valuing or everything from
run me through all the catastrophes that you can come across.
A lot of it is around valuation. So obviously, at the end, the person leaving will say the value is X, whereas the person in so no, the value is Y because we've got a lot of costs that we've incurred. We've employed more staff. Our revenue in the last year hasn't been great, even though the previous years were good. And then the individual who wants to exit says, well, I was there at the beginning. I was the one that started this practice. I grew it from zero to X millions of dollars that it is now. And there's a lot of disputes around it. And then the document might not say, well, if you can't agree on a value, what happens then? Right. So you haven't got sort of provisions dealing with who the independent valuer is. If you don't agree with the independent valuer, where does it go to next? Is there another sort of independent body that can help step in and get that valuation? We've seen all those sort of disputes.
Okay. So essentially we got to the end before you even started now.
Correct.
Okay. So let's bring back to the original scenario. So from the lease or purchasing a property, we probably need to get a lawyer involved. And then after that, I guess you got to hire a practice manager.
You got a receptionist. You've got if you're starting to get bigger, a nurse. You got to think through your employment arrangements and contractor arrangements and making sure you've got the right documentation in place. Again, I think we've discussed in previous podcasts, we've got lawyers who specialize in that particular space when it comes to employment. Look, employment law in Australia is complicated. Can't talk about what it's like in other jurisdictions, but I think traditionally employment law is important because Australian employment laws tend to favor, as a general rule, employees. Right? So making sure that if you're a business owner or you're a practice owner, having the right legal infrastructure in place to make sure the documents protect you as insofar as possible, and also not just protect you, but the employees know what their rights and responsibilities are under an employment contract or under a contractor agreement if they're being engaged as a contractor is really important. And making sure that you're not crossing, I guess, legal regulations that put you to put you at risk or make you fall foul of Australian employment laws is really important as well.
Yeah.
So,
what are some of the
employment
examples that you've come across? I mean, you got to pay people right. You got to make sure their awards are right.
Wage theft is a massive issue at the moment, and like we've seen that across the board in the media, not just in the medical space. I think the medical space has largely been untouched by this sort of regulatory enforcement, but you've seen it in big companies, whether it's mining companies, whether it's financial services, where there's big franchises. The regulators are out there making sure that people are complying with minimum wages, making sure they're complying with awards, making sure your contracts need to be structured in a certain way so that they identify the right award, identify the right classification the employee falls into, making sure that there aren't provisions in there which breach kind of employment laws. That's important as well, because it's very easy, I think, for employees coming on at the time just to sign something, but then when the relationship falls foul later on, the document is what people will generally go back to, and the document's not in the right shape. It just gives scope for the employee to kind of raise various issues that just create an issue for the practice.
I mean, I guess there's always the awards that are a guidance to go on, and I'm often told in medical, I think a lot of that problem hasn't come with the wage theft because most people end up paying a bit above award rates.
Correct. Yeah.
So from the wage theft perspective, that's not too bad. But I know superannuation is always an issue because you pay the superannuation quarterly, which is what's required. Whereas in the public health system, you're paid with every pay cycle. So there's that difference, and people forget, and I think once you get delayed by a little bit, they start slapping you.
Exactly.
fines.
And then you've got the Adelaide of complexity where you've got obviously doctors who are working in a practice
and contractors,
right? But then you've got those facilities and service arrangements, which is where all the payroll tax issues come in. So you can have employed doctors, you can have contractor doctors that are on an hourly rate, and you can also have doctors who are essentially they're charging you, the practice, a facilities and service fee. To allow them to run their independent.
Well, you're
practice.
Charging them the facility.
Correct. If you're an owner, you're charging them. But then you've got situations where you could be a practice owner. So you're a shareholder, you're a director in the practice medical services entity. That medical services entity is also providing service to potentially you as an independent health practitioner as well as a doctor. So you've got these two hats that you might be wearing. So that's quite a common arrangement that's in place for a lot of practices. And
we do see that from a structuring perspective.
Yes.
Like once you go over, once you're not a solo practitioner, you tend to have that sort of tenancy and independent practitioner.
Correct, like facility service arrangement. And then you at that point you might bring in associate doctors as well. The associate doctors will come in. They'll come in on these facilities and service arrangements where the practice entity is basically charging a service fee, which is usually a percentage of billings. But then over time, you might want to say, look, these associate doctors, they've built up their own practice. We're getting a great cut off their service, the service fee that we're charging them for them to run their practice. We now want to bring them in as a shareholder and then let them become a principal and an owner within the practice as well. So we go back to the setup is really, really important. And then you got to then think through, well, at some point, again, I want to exit. How's that going to work? So again, going to the end is important.
Okay. So now, we've, I've set myself up. I've got, I've got a sonographer, I've got an ultrasound machine, I've got reception staff to do all these things we talked about. And precisely, I want to bring on another person as a contractor, right? So you mentioned the two different forms of contractor, whether they're just leasing rooms from you or we're taking a percentage of the service fee. How is that viewed differently from a legal perspective?
Correct.
I mean, taxation side is also viewed slightly differently. Give me your take on that.
So look, you can come in, typically an associate will come in as a independent health practitioner under the facility and service agreement. You would charge, the services entity will charge them a service fee to use the space, use the practice management software, engage with the nurses to kind of run their practice. That's a typical arrangement. But sometimes you've got doctors who want to come in as, and we're seeing more and more of this, on an hourly rate. They want to come in, they want to act as a contractor on an hourly rate. They're acting as a representative of the practice when they're in that particular space. Essentially, they can end up becoming employees for, in some cases, superannuation, depending on how they're structured, whether they've got a PTY limited company that they're in contract with the practicing on, or they can be an individual sole practitioner. And we do see a lot of doctors kind of come into that space. In some of the bigger corporates, sometimes a doctor will wear two hats.
Yeah.
They'll have an independent contractor where they're doing their, regular, for example, GP services that they're rendering to their, giving to their own individual patients, using the site to do that and getting charged their 30% service fee. But then they might go, I also want to do some, for example, urgent care work, right? In the urgent care clinic next door. I'm going to be a contractor for that purpose. When I'm walking next door to do urgent care, then I'll be on an hourly rate, whatever it is, $150, $200 an hour to do that work. And sometimes they might do it in two different locations. There might be a locum over here doing contractor locum work, but an independent health practitioner, getting charged a 30% service fee over here. And then sometimes
that gets complicated.
And then sometimes again, they go, oh, I actually also want to be an employee. In this, particular, if I'm, working in a particular business, an employee one day a week. So I was starting to see like the whole spread of arrangements in that particular area. And then again, we started to see license agreements. So people were saying, look, I literally want to use this particular space one day a week on a sessional license. Sessional rate, right? Okay. I don't want to use your practice management software. I don't want to use your nurses. I just
this is
want
like a meet and greet
the space. Yeah. But I don't want to enter into a lease because a lease is just a bit more onerous. There's a bit more regulation around it. I just want a sessional license arrangement. So we're starting to see a bit of everything because at the end of the day, as the medical profession is diversifying, we're seeing just people looking for a lot more options. To kind of practice in a different way.
I mean, that's just a lot. So the first one is, I guess, let's break it down one by one. Sessional rate, you go in and say, I am renting this space for X amount of money each time. I don't need any of the other stuff. That's usually the sessional rate model. That's very popular in the, I guess, specialty, the non-GP specialist space. And the location seems to be, the thing that really gets them there. Then the next version is you're a contractor on an hourly rate. All right. So it's almost very similar to how a VMO would work in a public hospital. You get an hourly rate, and I find that often those because the company or this entity is viewed as almost like an employer sort of situation. There's probably superannuation
depending on how they're
implications, depending on how it's structured.
And payroll tax implications as well. And if they're depending on how many days they're working.
And then there is the percentage service fee model. And again, I think that's quite prevalent across GP specialty.
That's the main way of engaging. I think at the end of the day, it respects the doctor's independence. And the doctor is running their own practice, but they're using the facilities and services of a practice or medical services entity. That is charging.
And it seems like 30%. This is the area where a lot of the payroll tax debate is happening.
Absolutely.
Especially in general practice. And especially if they're not working across multiple sites. It's like if you're a solo site, you're working in the same place. The payroll tax liability seems to be...
It increases your risk profile.
Risk for that. That's a good risk profile. And then obviously the last one is you're just employee.
It's just employee. And look, there are some, obviously if you're in public health, then you're generally speaking, if you're coming up the ranks, you're an employee. But we are seeing employment arrangements against some of the bigger corporate health practices as well. I mean, there are usually lots of incentive structures that are sort of in play.
So is that a base plus bonus?
A base plus a whole bunch of bonuses depending on sort of your performance. And look, I mean, some doctors like that because it just gives them certainty. And it means that they're cutting a wage and they've got leave that they can take, whenever they want in accordance with the company's policies. And also the companies like it because it gives them certainty in terms of, I know that I can control when a doctor turns up or doesn't turn up in the services that they deliver. So you see that in, for example, some of the larger, for example, cancer clinics across the country. We do see that there are doctors who are getting employed because obviously, those clinics want to be able to really direct the doctor in terms of the actual care that's been delivered. We're seeing that in some of the telehealth spaces as well, where doctors are sometimes coming on as employees now because you can direct the clinical outcomes in terms of how the telehealth is delivered or how certain services are provided to the client. And it gives that unity of branding, right? Which is really important. Whereas I think that
you can dictate
exactly how the brand is and how it positions itself in the market when it comes to delivery of patient services.
Okay. So it sounds like there's that whole sort of
so it's broad spectrum
from I guess the engaging practice with the doctor and how that relationship and who holds the power for certain things.
Correct.
What are the various taxation and
Yep.
I guess also medical legal liability.
Medical legal liability, and end of the day, it's sort of like certainty, cost benefit analysis, risk profile.
Yeah.
And you look at all those things and then you kind of work out, well, what's the best way of structuring? And also like sometimes it's like if you're a practice, how much flexibility do I need to give the doctor that is and I'm engaging with to make sure that their needs are met and my needs are met as well? So it's having that discussion and working through that is really important.
Okay. All right. So we, back to our scenario.
Yeah.
We got a couple of people working in the practice now, and there's a new cardiologist that really want to become part of the business.
Yeah.
So I've done what we said. I've got a shareholders agreement.
Yeah.
To get a constitution as well.
A constitution. Yeah.
All right. And tell us, what's the difference between a constitution and a shareholders agreement?
Yeah, so shareholders agreement are governing the rights and responsibilities between the owners of the business.
So the shareholders.
Shareholders. Whereas the constitution is really there to kind of work out what's the governance around the company, how are meetings conducted, how are certain directors meant to relate to each other. If we want to get certain decisions made, what's the process in making those decisions between directors within the business? So the constitution is focusing on in summary, the directors and what they need to do to run the company, whereas the shareholders agreement is trying to work through how do the owners of the business,
so the ownership
issues and how they interact with each other. How they come, how they go. Whereas the constitution is more on the governance of how the actual board and the directors are interacting with each other. Okay. Yeah, but there is overlap, but that's essentially the sort of separation between the two.
And in the interesting case of a doctor becoming a shareholder, very similar to a law firm, a lawyer become a partner, because they are bringing in their own clientele, I guess, in some way. And sometimes they're coming with nothing. How do you, how have you seen these things play out in terms of valuing the person coming in, or how much do they need to buy in? Because there's talk about buy-in. There's talk about we're just giving you a share because you're also bringing in additional business. How does that sort of work in general? The considerations, I guess. Absolutely.
Yeah. I mean, sometimes you have to have the parties have a discussion about what the valuation is and how much they want to buy in. And again, the shareholder units agreement will cover or should cover how that mechanism for buying in looks like. But what we typically see is you don't want someone just simply buying in. You want them ideally to have built up a practice already that's connected with the medical services entity.
Or they're buying and working.
Yeah, correct. Like they're basically they're associates. They've been there for a period of time. They've built up a bit of a following and obviously generating revenue that's coming into the practice through this kind of servicing arrangement. And then you say, well, you know what? Given that you've done this already, we're going to give you an opportunity to exercise your rights as to become a shareholder. You come in as a shareholder, we'll issue you with shares, and then the shareholders agreement should kind of set, I guess, minimum performance, arrangements in the shareholders agreement. The last thing you want is for someone to come in, they build up a practice, they become a shareholder, and then they stop working. They start disappearing. So having the right mechanisms in place, and those will look varied, and there'll be different sort of performance mechanisms that can be built into shareholders agreement.
Is that quite common?
That is quite common. Yeah, we do see that and that's where the disputes happen.
Yes.
So people, and look, it doesn't happen straight away, but what we see is over time, they kind of go, well, this practice is doing really, really well. There's plenty of profits coming through the medical or the practice services entity. I think I'll just take a back seat. And kind of just fade into just coming in a lot less to kind of practice medicine from this particular place, from this particular service.
And what sort of I guess the typical kind of clauses? Is it minimum hours a week, or is it minimum days a week?
Yeah, everything from minimum hours or minimum revenue generation. We can kind of put those sort of things in there. We're going to be very, very careful. Obviously, you don't want to sort of fall foul of, payroll tax compliance as well. Yeah. Because that can get
onerous.
Correct. That can get very complicated. So if it looks like you're controlling, I guess, what a practitioner is doing or not doing, it gives rise to this kind of. I can see why a revenue office would look at it and say, well, actually, that person's acting like an employee for the purposes of payroll tax, at least. Yeah. So we need to kind of again, without going into the specifics, we do sit down with the doctors and the practice owners at the start to kind of work out what works for them and to kind of really set some parameters around.
And does that have to be baked into the shareholders agreement, or could it be baked into a separate agreement on the side?
It can be separate on the side. I mean, end of the day, look, we're not generating documents for the purposes of avoiding payroll tax liability or whatever. That's not appropriate. What the lawyers are there to do is to kind of help, I guess, get a structure which reflects the independence of the doctors, but also comes up with mechanisms that allow for meaningful ownership engagement, right, within the shareholder unitholders agreement. So, and the distribution of profits that come from the practice.
Maybe how does it work in the legal profession? What are the?
Yeah, look, it's interesting. In the legal profession, there's a couple of options. Sometimes, if you're incorporated legal practice, you'll become a director and a shareholder of a practice, similar to doctors in a practice in a PTY limited company. And then there's issuing of shares and profits that come from that. A lot of the bigger law firms will typically go down the route of a formal legal partnership. So that's slightly different. So legal partners, they're not directors, they're not shareholders, they are part owners in the business. They're what they call jointly and severably liable. So each individual is tied to every other individual. They're essentially running their own businesses, but they're tied to each other in terms of their legal liability. But it's a mechanism for sharing profits more effectively. A lot of
Do we have that in medicine?
They do have that in medicine, but less common. Less common because I've never kind of worked out why, whether it's just a legacy issue. But I think that the reality is that law firms, because their ultimate goal is just profit sharing, they're not thinking so much about, I guess, whether it's, whether the directors and the legal compliance that comes around with owning and being part of an entity. The lawyers tend to not want to, this is my take, the lawyers tend not want to have to go through the compliance that comes with having a PTY limited company. So having a PTY limited means you've got to report financials in a certain way, et cetera, et cetera.
And especially after you get enough people in it,
Correct.
Correct.
Yeah, exactly. Whereas the partnerships, in the legal partnerships, they don't have those legal compliance with ASIC and whatnot as much. So
what structure is that? It's not a company.
No, it's a partnership. Yeah.
It's like just like the partnership in the pure terms of partnership.
In the pure sense. So that's what a lot of law firms.
And there can be lots and lots of people in that partnership.
Lots and lots of people, but the partnership arrangements are usually very, very complicated because, again, as I think we mentioned in previous discussions that we've had, you've got people coming in as salaried partners. They get tested for a period of time. Once they've hit certain financial thresholds, then they become equity partners. Once they become equity partners, depending on how much revenue they're bringing in, they'll have certain units that are issued. Those units can be valued in a certain way from year to year. It gets very, very complicated.
But it can be as complicated as a company. Almost.
As a company, right. Correct.
But then does it allow for more flexible sort of profit sharing mechanisms?
I think it's more correct.
To more shareholding, because the shareholding.
Yeah. Shareholding tends to be fixed, right?
Yeah, fixed based on your share percentage.
But it's a lot more simple. Yeah, whereas I think that's why my take is that's why a lot of doctors just go down that particular route. Whereas I've seen some partnership deeds, they literally go on for pages and pages.
Well, I mean, you have the expertise to review that and execute that. Whereas each time if a doctor wants to sort out a partnership agreement, they've got to engage a lawyer to do it. Whereas you guys just do it in-house.
Yeah, whereas it's a lot simpler, like simply issuing shares to say we're now issuing a set of shares under the terms of the shareholders agreement. It's a bit more simple.
Yeah. So the partnership agreement is actually way more flexible.
Yes, but more complicated.
Complicated. Yeah. I guess the legal costing is probably one of them.
Correct.
Do you see that there might be medical legal indemnity reason for that? Or?
Yeah, and I think that also from I'm not a medical legal indemnity lawyer, but having a sort of a joint and several liability arrangement is not ideal as well. So basically says that if the doctor over there screws up, then all of you, if you're in partnership with each other, you take the same responsibility.
Yeah.
That's probably another kind of consideration as to why doctors don't tend to go into formal legal partnership arrangements. Whereas obviously as a shareholder, unitholder in a medical service entity, that's a medical services entity. You still have your independent sort of health practitioner.
Yeah, you're not personally liable. Yeah. Maybe that's
that might be it.
So why are lawyers not afraid of liability?
I don't know. Maybe they're just up for the profit share arrangement. They're like, we'll take the liability. And look, I think that's why they end up taking on people in partnership who they trust and know for a long time, and they kind of work through the ranks. You rank them through the ranks. You've seen them operate. You say, I really trust this person. They're generating revenue for the firm, but we've observed them for 10 years, 15 years, or
because
whatever.
If there's a malpractice on one of them, it's across the firm because they're jointly
and severally liable.
Interesting. Maybe that explains why some of the legal TV shows all portray that quite nicely.
Correct.
If someone does a malpractice, it's everyone.
Yeah, everyone gets tainted.
Everyone gets tainted. Yeah, interesting. Okay, so when someone buys in, right, and they've paid for their share if they pay for their share, and now you're co-owners. And in the future, you may want to bring other people on. So you got to have that shareholders agreement
to help you with that, facilitate that process.
Do people put the pricing thing in there? Because I think now we should talk about pricing in terms of how are these things usually priced?
Usually there's a mechanism for valuation, and this is where the accountants come in. It's probably touching slightly beyond my sort of expertise, but usually at this point we get the accountants to come up with a structure for valuation, and then the lawyers will simply reflect that structure with the right kind of legal wording, so there's no ambiguity as to what it is that needs to happen at a particular point.
So someone does the maths, someone does the maths
and say, look, we've done the modeling, we've looked at your practice, we've looked at how you want to kind of model everything. This is the mechanism. Now lawyers capture this in writing for us so that on exit, we know exactly what needs to be done and how this needs to be valued and what are the metrics that apply.
One of the issues is that when you first start off with that document and then later on you're exiting, you could have been entering in at a 2-practitioner practice.
But it becomes a lot larger.
In say 20 years, that's like a 20 practitioner practice.
Correct.
The way you value that would be also different, wouldn't
Very
it?
different. And that's why I think you need to constantly come back to that document. Is it fit for purpose? Are the mechanisms right? And you obviously want to do that incrementally as you bring shareholders on board and you bring people into the fold, into the ownership. Reassess that document regularly. The last thing you want is to kind of put that document in the drawer. 20 years later, 30 years later, someone's about to exit and the document just doesn't do the job anymore. Right? Everything from the valuation mechanism to the exit mechanisms to how that person exit just doesn't cover what's needed. So revisit that document regularly.
Okay. And broadly speaking, does that is it usually a multiplier on
multiplier usually
on the profit?
Correct. And also you got to think through, like, I mean, this is obviously buying into a practice. We need to talk about like selling a practice to someone, the entire practice to someone else. Again, there's different mechanisms around that as well.
Okay.
So
all right. So this is just talking about individuals buying in and selling out of a practice. So you need that mechanism for if someone want to come in, someone want to exit.
Correct.
That's all fine because there's issues that prop up.
Absolutely.
Personal circumstances.
That's right.
Death, disability, and all sorts of things. And divorce.
Divorce as well.
That gets. Have you come across some situations
we do not sort of as common as we'd expect, but we do come across that and making sure you've got mechanisms in place to allow for exit in certain circumstances, whether it's death or permanent disability, having those right clauses in the shareholders agreement is important as well.
And my understanding is that there's insurances that the practice can actually take out in the event of a death or disability.
And at an event, we've got a team of people that help you kind of get the right coverage, give you the advice to help you kind of work through, well, what do I need to cover that particular scenario? If I get permanently disabled or there's death.
Okay. So that's easy. Death and divorce. Death and disability. But divorce, you don't have insurance for divorce.
No, you have insurance for divorce, and that's when we bring in the family lawyers to kind of give that guidance. And look, I haven't personally come across any divorce cases as yet, but we've got family lawyers that we refer people to if that comes up.
And then they will put a valuation on the practice.
And then to kind of work out how to break up this thing, and what it's worth.
And how to price it as well.
Correct.
That's interesting, especially if both the couples are involved in the practice.
Exactly.
It's very messy.
Exactly.
Understand. Okay. So at this stage, we're still, mid-career. We're getting people in. There's people that want to exit. So we put a legal framework in there for the fluidity of that.
So the practice to operate.
And everyone that comes in as a new shareholder, they will basically sign the shareholders agreement, whether it's the old shareholders agreement or an updated shareholders agreement. And basically you need, enough. You need everyone to sign.
Correct.
Each time
to agree.
To agree to it. Right. And you put some governance structures on that with the constitution. And so say now I'm getting towards the later stage of my career. I just want to wind down. I can't be bothered running a practice anymore and overseeing 10 different cardiologists. and a big corporate comes and says, I want to buy the whole thing.
Yeah. That's a real opportunity. Yeah. And we're seeing a lot of that.
And now say we have already 5 partners in this
Yeah.
business.
Yeah.
Okay. Talk me through the process,
of
that, because that gets complicated, very complicated.
So obviously, before you even go to the legals, it's about getting aligned. So having the shareholder, unit holders and all the owners aligned, say, yes, we're at this stage where we want to realize our investment in this particular practice. We're seeing increasing corporatization across the medical settings, consolidation, i.e. you're getting big companies buying smaller practices and bringing them into the big ecosystem that they already are. It's happening everywhere.
Private equity, right?
Private equity. A lot of the health insurance companies are doing the same thing. As we know,
dental practices,
dental practices already started.
A good example.
Dental practices already started, but it's happening across the board, especially in the medical space. So ideally you have a number of suitors, people that you can choose from. But assuming you don't, it's then sort of working out. And I now want to sell this practice. Is my practice set up with all the right documentation so that when the bigger corporate comes knocking on the door, I'm ready to open up my doors to say, here it is. Here are my structures. Here are my governance structures. Here are my employment contracts. Here are my doctor contracts, all in place. And then you've then going to work out, well, I want the terms to be sorted out. What are the terms of this acquisition that are going to be involved in if I'm selling to a larger corporate? I want to make sure that typically the corporate will say, well, okay, we'll buy you upfront for a certain amount and give you and the other shareholders, unit holders, a certain amount upfront, but we want you to stick around for a period. It's what they call the earn out. Like if you want to get a bit of a balloon payment at the end, we'll give you an upfront payment and we'll give you another sort of additional payment. We want you to stick around. That's where you want to get your accountant kind of structure the numbers to make sure that the earn out does what it's meant to do. Obviously it's got to work for the corporate that's acquiring, but it's got to work for the individual doctors and the shareholders as well. And also getting the valuation right. So what's a multiple? What's a multiple of the EBITDA that we say is a multiple of 4, 5, or 6? A lot of the larger corporates will buy a smaller practice at 4, 5, or 6 multiple of EBITDA. Then at a later stage, 4 or 5 years later, once they exit at 10 or 12, whatever it might. That's how everyone makes their money. So that's sort of the broad process. Once the corporate comes in, they usually want to do what's called due diligence. So that's an opportunity, as I mentioned before, for the corporate to look at your books, to look at your operations, to kind of look at your financials, to go, is what I'm buying consistent with what my valuation and my modeling says this practice is doing and should be able to do as it continues to grow, as it is brought into the ecosystem of the corporate. So that will involve looking at your employment contracts, obviously your doctor contracts. It'll be looking at your policies and procedures. Have you got the right governance structures in place? And obviously the financials. They'll want to be very keen on the financials, and that's where the accountant will be able to kind of help you navigate through what do we kind of hand up, and the lawyers can also look at it and kind of go, well, are there things that don't need to be provided, that don't meet the requirements of the request from the corporate? What are the requirements? Hand it over and then sort of address any questions. So typically there'll be what's called these requests for information. So what they call RFIs, or there's different terms for it, but essentially they'll ask questions about the practice. And once they've done all that, sometimes they'll come up with what's called a term sheet. So, or concurrently come up with a term sheet. The term sheet essentially captures the key terms of the deal. Who's coming across, what the value is, what the termination arrangements are, when does a deal need to be signed by, when does it need to be completed by, what's the upfront payment, what's the back end payment, are there any restraints of trade that need to go into the business sale agreement or the business purchase agreement.
Because you don't want to buy and then...
Correct. You don't want the buy and then they just turn around and go next door and set up another practice, right? So there'll be all those sort of requirements. What liability are we taking on? What warranties are we giving? What warranties are we not giving about the business? Warranties are basically like saying that I warrant that the business is in this state or that state, or it's got no issues here and it's got no issues there. What's going to go in that agreement? Once the term sheet's been signed off, the due diligence has been done, the financial and the legal due diligence, then typically you prepare the legal document. That's where the lawyers really get involved, and they just kind of want to make sure that all the obligations that are reflected in the term sheet and all the legal requirements have been satisfied. Everyone's happy, and then you sign. Once you've signed, then there's usually what's called a period of completion. So you've got to complete on the deal. Similar to buying a house, right? So you buy a house, you put the deposit down, you sign, and there's a period of whatever, six weeks where everyone just kind of makes sure all the documents are moved across, everything's in order, and then you settle. So that's essentially the sort of the sale process of a business, and everything gets transferred across your domain names. If you've got a website, any registrations that need to go across, employees need to go across, any leases that need to get sort of assigned. All that process happens. And
often do you find that a lot of the leases, the contracts just get re-signed as status quo, or do they often change as well?
It varies. I mean, usually if you've got doctors moving across, typically the buyer will want new doctor contracts, right, that suit their particular circumstance. So there'll be new doctor contracts that are negotiated. Sometimes the employees will get new contracts, but typically they want to make it easy for the employees to say, look, you can come across.
It's usually the same thing.
Usually on the substantially similar terms. But if they look at your employment contracts and they go, these are very different from our employment contracts on our end, then they'll say, look, we need, we're going to issue new terms. They're substantially similar to what the employees are on in terms of pay and title and whatnot, but they're sort of on new templates. So that will happen. With the lease, it's usually a bit more straightforward. The lease, it's just pass it on, right? It's called an assignment of the lease. You're just going to make sure that the assignment provisions are complied with and consents obtained from the landlord, et cetera, et cetera. So,
I mean, the landlord can't just say, oh, no.
No, typically they can't, but at the same time, you just got to look at the provisions to make sure that, and I guess, that's part of the arrangement when you're setting up and you're doing the lease. Make sure that you get sort of, and you're thinking of exiting, make sure the assignment provisions don't create grief for you on the way out.
And that's all very good when everyone agreeable. Right. So let's just go back to our scenario where we have 5 partners and maybe there's another 5 non-partner cardiologists that work in this practice. Now, 4 of the partners are happy. And one doesn't.
One isn't. One's holding out.
There's always one. There's always one guy, right?
Yeah.
What happens then?
Look, I mean, there are mechanisms. Ideally, you get everyone to get agreement, but if you can't, there are sort of what they call drag along and tag along rights. They can go into shareholder units agreement, where you've got a majority of people that have decided that they want to take a course of conduct, but you've got one person holding out. Again, those particular provisions, you want to set those up in the right way from the start, so that if you've got a majority of people, 4 out of 5,
or a supermajority,
but you've got one person holding out, there's mechanisms to kind of require that person to come along the journey as well. And
I understand what those terms are. Briefly explain what's drag along. I guess drag along is that one person that's holding
along,
out. You're dragging along. And
the tag along means tag along is basically like you get the opportunity on a positive way to tag along with the rest of the people who are going in a certain direction. So you get the benefit. So you might be a shareholder with less rights than some of the other shareholders because there's different classes of shares.
Say you're a minority.
Correct. But then you get a chance to tag along with whatever position that they're going on if there's a unified decision to go in a certain direction.
Okay. So for instance, if we have 5 people in there, 2 people are selling to someone else. And you also want to sell, but that offer wasn't put to you.
Correct.
You could say, I want in on that.
I want in on that as well. And be tagging along with the benefit of that.
And then obviously then the person who is buying will have to assess, if they only want a certain percentage, they might take equal share from everyone or some other way.
Correct. Absolutely.
Okay. So you can't exclude anyone, and you can't.
You can't also have someone holding out, which is like I'm just holding out indefinitely. Even though like 80-90% of the people are ready to go. On this deal.
So I guess when the individual doctors are signing these partnership agreements, they should understand what it actually.
Correct.
Shareholders agreement.
And tailoring those shareholders agreement to the particular needs.
Scenario. Okay. And in a situation where the 5 non-partners, I mean, they obviously don't have a say in whether to sell or not, but they can always vote with their feet whether to.
Vote their feet. They can stay or they can go, but obviously
that will affect the valuation.
Correct, right? So if you can kind of secure them and to get their buy-in to kind of stay and to continue using the medical services entity for the purposes of them delivering independent healthcare to their patients, then that's going to allow you to kind of, I guess, crystallize your value a bit more, especially with the person acquiring it.
Yeah, that's very complicated process. Obviously.
Oh, very complicated. Yeah, and obviously,
how long does that drag on for?
Oh, look, I mean, look,
quick to.
We try to look. It depends on the needs. Sometimes we had one client that wanted to drag it out a little bit because they knew that the corporate was keen on them. The longer they drew, part of the strategy was drag it out a bit longer. We want to keep him keen.
Yeah.
But then other people are like, no, we want to get this deal done.
Yeah.
We want a cash in hand now because, we want to get in on the action and get the benefit of the upside of our investment. We've been working long enough to build this practice. We'd like that, to crystallize and realize that investment now. So it just really depends on the strategy that you want to employ. This particular client that we were acting for, they were younger. Some of them were non-doctors, so kind of had sort of like bought into the business, and they were very much like, well, we're running a very successful practice at the moment.
Yeah.
Let's just drag this process out a little bit longer to get a bit more buy-in and potentially a higher price from the corporate.
Beautiful. Yeah. And I guess the last thing is, if I wanted to buy other practices, you talked about it from the seller side.
On the buyer
side is also
we
very
see that,
similar. You get
very similar. Like, absolutely. I think if you're in identifying the right target is very important. What we're seeing is we are seeing practices acquiring smaller practices. The deal looks great at the start. All the legals cover everything off, but the personalities were not right from the start. So you buy a practice, the doctor comes in, they're meant to be doing what they're doing, but actually it just causes relational issues. Yeah. So if anything, it's not a legal issue. Yeah. The documents can do whatever you need to do, but the documents should be the last thing that you rely on. You actually want to make sure the relationships are right. So finding the right target, finding the right practice to acquire. Does it have the same ethos when it comes to the delivery of healthcare and the running of a medical practice? Finding that is really, really important. And then capturing the legal document to kind of protect you.
It sounds like they need some relationship advisor.
Yeah, I think so.
Is there such a thing?
Look, I don't think that there's a relationship advisor, but I think that sometimes practices, they want to scale, which I get. They want to scale quickly. Yeah. And I mean, I've advised, practice on the buy side in the small to medium size, as well as the bigger end of town, if you want to call it that. And the same issue comes up all the time. You end up seeing the opportunity to buy a practice that's got good patient flow, good patient revenue, but there's relationship issues with the principal. But even if there aren't relationship issues with the principal of the practice, there might be relationship issues across the associates.
Yes.
Right? Yeah. So you acquire this particular practice, great deal with the practitioner, but what has been investigated is that half of them leave or they're all fighting with each other, right? So doing that due diligence, relationship due diligence, operational due diligence is really, really important from the start. Yeah. So as well as the legal due diligence as well.
Yeah, I mean the legal thing is the one that it's almost like the insurance. You don't want to.
Yeah, correct.
You don't want to invoke that, but
you don't want to invoke that unless you have to. Yeah. So you've got to get it done. It's your insurance. It's your backup. So when it all falls to pieces, it goes pear-shaped, you've got something to kind of lean on. And look, we have seen practices that have just gone and done that themselves and it's caused problems. So
when the times are good, nobody's complaining.
Correct. It's when there's a divergence in interests, that's when it becomes a problem.
Yeah. And I think that's one of the problems with dealing with the legal profession is that you don't hear about lawyers until something goes wrong.
Correct. They're always attached to problems.
There's not that positive engagement process.
They're always attached to problems.
Of people. Yeah.
But hopefully, you find a lawyer that will help you problem solve, not problem create.
Proactive about it.
Yeah.
Beautiful. So anything else to add from our clinician now? He's happily sold his practice.
He's got his millions or her millions.
Hopefully,
and I guess the next thing is what do? They kind of invest in more property, or kind of find another place where they can just kind of retire and just kind of work chill. Lesser hours and chill.
I don't think a doctor ever retires. But anyway,
I don't think so.
My thought. No. They can come to us and find out where to invest.
Absolutely.
Awesome. Thank you for coming again.
No, it's my pleasure. Thanks so much for having me.
This podcast is for educational and entertainment purposes only. The information and opinions shared are not intended as personal financial advice. The content presented should not be relied upon for making financial, investment, or other decisions. Listeners are strongly encouraged to seek the advice of qualified financial or legal professionals before making any financial decisions. While we aim to provide valuable and accurate information, we make no guarantees regarding the completeness or accuracy of the content. Any reliance on the information provided is done at your own risk.